my colleagues will be discussing some of the changes that came into effect at the end of March this year. We've got some new ones coming in. So a little bit about who we are. Housing Justice is a program of ARC Justice, and we support vulnerable tenants in our region to sustain their tenancies predominantly, and we do our best to ensure that people know their rights and responsibilities as a renter. We're located in Bendigo, which is Dja Dja Wurrung country, and no doubt some of you will be on various other lands such as Wurundjeri or Yorta Yorta country. I'd like to pay my respects to anyone here today that identifies as Aboriginal or Torres Strait Islander, and all elders past, present and emerging. Please feel free to pop in the chat box which country you're on today, because we'd love to know. Now, just to let you know, we'll be recording today too, so I just thought I'd better let you know that. And Alia is our moderator for today, so she'll be keeping us on track, and she'll email you the presentation and slides when we're finished. So just a little disclaimer, this presentation is for Law Week purposes, and I just would ask that people don't take that as personal legal advice. If you need legal advice, you would need to speak to Tenants Victoria, and there's some other great organisations that we'll talk about throughout the presentation as well. Now, as you probably know, we put you all on mute for now. We just want to make sure we get through everything, and then if we've got time at the end, we'll do questions. And just pop them in the chat box, and because we might have some things happening. And also, because it is so new, we may not be able to answer everything on the spot, so we'll just let you know that we'll either get back to you or direct you to another organisation. Thank you. Okay, so topics for today, we'll be focusing on 3 areas of tenancy law that has changed. I wish we had time to do more, however, there's just like over 130 changes, so we have chosen just some common themes, and they are minimum standards, urgent repairs, and mainly arrears and evictions. You'll notice, or you may or may not have noticed, there's a new terminology that is now in place. So landlords have gone and are now rental providers. So that's a welcome change. And tenants are now called renters, and leases are now called rental agreements. We may abbreviate some words throughout the presentation today. So if you hear CAV, you'll know it's Consumer Affairs, and vacate is Victoria Civil and Administrative Tribunal. Okay, so we'll move on to minimum standards. This list here is all the minimal standards that have been introduced. We won't touch on them all today. There's some ones on there that really should have just been there all the time. So having a working toilet, and kitchen, laundry, window coverings, windows, lighting, correct lighting and what have you. So we'll just focus on a few of those. So as of the end of March this year, all properties must have deadlocks or be fitted with locks that can be unlocked with a key from the outside, but unlocked without one from inside. That's just a safety precaution. And they all must be structurally sound and weatherproof. So that's good to know that they've introduced that. Be free from mould and damp caused by or related to the structure, the building structure. Be careful with that one, because just from our experience, rental providers tend to, some, I won't say all, tend to put the blame onto the renter. So if you need any more advice about that or information, please contact us. Now this next one, the electrical safety, comes into play end of March 2023. So that means all outlets and circuits must comply with Australian standards. And as of the end of March, or 29th of March, 2022, all properties must have window coverings that are in bedrooms and living areas, so curtains or blinds that can be closed, block the light out and provide privacy for people. And we'll have a bit of a drum roll. So all properties must have fixed heating in the main living area. So I don't come across many people who don't have heating, but it's just good to know that it is now a minimum standard. Right, we'll move on to urgent repairs. So we've listed all urgent repairs. The ones in blue, that's the newly introduced ones. And all the other ones have been around since 1997. So it's good to see that the cooling appliances are now in an urgent repair. So if you're in the middle of summer and it's stinking hot and your air conditioner dies, it's now considered urgent, which is fantastic, particularly up in our region where it gets really hot. And also, this is good to note, so if you do enter a property and it doesn't have the minimum standards, that is considered urgent and must be seen to immediately. Safety-related devices such as smoke alarms or pool fence, they're not working, then that's also urgent repair. And any fault or damage in the property that makes it unsafe or insecure, including pests, mould or damp caused by or related to the building structure, which was what we touched on before. Welcome to the person who's just come in. Sorry that we're chugging along. We're going to now talk about arrears and evictions. We're happy to spend a little bit of time on this because this is there's a lot of branding, but this is it's a great change and we're so happy to have it. So we'll talk about rent arrears and the 5 strikes is what people are referring it to. And we'll also discuss what to do and what to look out for when you get a notice to vacate because the rental provider is selling. Another one that's quite common now that we're seeing just post-COVID is the rental provider is either moving in or a person dependent on that rental provider wants to move in. And the last one is the reasonable and proportionate test, which, you'll enjoy this. I'm going to hand it over now to Lyndall. Actually, before I do that, I will just pop this up here. This is what I was talking about before. So these organisations are fantastic and their websites are very clear to understand and they've got great resources that you can print out. And Justice Connect has a Dear Landlord section that you can go into, and that has all like pro formas of how to word letters to your rental provider. So I'm going to kick over to Lyndall. She is doing no, she's not. I beg my pardon. It is Leah, and she's going to be talking about the 5 strikes and changes with rent arrears. Thanks, Leah. Just want to unmute yourself. Yeah.
I thought you were rearranging things and I was getting a bit scared. But hi, I'm going to talk about rent arrears and what we're calling the 5 strikes. So if you get into rent arrears, so the first, second, third and fourth time you're more than 14 days behind in rent within a 12-month period, the rental provider can give you a notice to vacate. This is a 14-day notice and becomes invalid if the arrears are all paid by the date on the notice, and vacate must dismiss any application for a possession order. If the rent is not paid by that date, the rental provider can apply to vacate for a possession order. At this hearing, the member can adjourn the matter, put the renter on a payment plan and refer them to a financial counsellor. The member will be looking at things like why the arrears have occurred and whether they think you can afford to pay it back on top of making your normal rent payments. If you are put onto a plan and you stick to it, VCAT must dismiss any application for a possession order. And that is a little bit different to what used to happen. So that's actually a good change. But the member still does have the power to grant a possession order at this stage. And I'll give an example. So if you've been in rent arrears a couple of times but been able to pay it back with the assistance, for example, of local housing services prior to the termination date on the notice, then, so that's all good. But then the next time you get into arrears, you might not be eligible to access financial assistance because you've already done it recently. So you might find yourself still in arrears at the termination date on the notice. You'll then go to vacate for a hearing, and the member may find that the rent is just too high for you and they believe that the tenancy is not sustainable. At this stage, the member will need to apply what's called the reasonable and proportionate test, and we're going to talk about that in a bit, to weigh up the hardship of the rental provider against your own hardship if you were to be evicted. If the rental provider is found to be in great hardship due to rent not being paid, it may be possible for vacate to grant a possession order and you could still be evicted. Finally, if you find yourself receiving a 5th notice to vacate within a 12-month period, that notice stays valid even if all the arrears are paid by the termination date, and a possession order can be made if the member is satisfied it is reasonable and proportionate to do so.
Thanks, Leah. Now it's pretty big. So I'm sure you'll have some questions that you want to ask us out of that. As great as it is, we were talking before and saying it's probably best not to try and take advantages of the 5 strikes, because you still want to try, to keep your a good rental history going for yourself. I know, look, we know things happen and you can't always pay rent and you have other commitments that have come up, but just good to know that it's there. But yeah, I wouldn't be pushing it. All right, so
yeah, you're not guaranteed that you won't get evicted.
Yeah. And like you said earlier, if the member thinks, even on the first notice, if he or she thinks that you can't sustain that tenancy, then they will, or they can grant that possession order, can't they?
Yeah, definitely. Definitely.
All right, so we're going to introduce Lyndall now. She's going to be talking about the rental provider selling and or wanting to move in. So thank you, Lyndall.
Thanks, Kirsty. Okay, so the rental provider is selling. So what needs to happen? So the rental provider must provide a valid notice to vacate, such as the property is to be sold. So this is a 60-day notice to vacate, and the rental provider cannot shorten the length of the rental agreement to give a notice to vacate for this reason. So what evidence must be attached to a notice? So one of the following pieces of evidence must be attached to the notice to vacate. So there must be a contract of sale signed by the vendor and purchaser and dated, or a contract of engagement authority to sell with a licensed agent, or the preparation of a contract of sale prepared by a conveyancer and an Australian legal practitioner. Okay, so the rental provider or a dependent wants to move into the property. So what evidence is required? So the rental provider, a member of their immediate family, this includes parents and in-laws or a dependent who normally lives with the rental provider, will be moving in. So again, the rental provider needs to serve a notice to vacate, and this is also a 60-day notice to vacate. So the following evidence must also be attached to the notice to vacate. So a witness stat dec signed by the rental provider stating either they intend to reside in the rented premises, or they actually have to now name the person who will occupy the rented premises, their relationship to the rental provider, and declaring whether this person is a dependent. Also, the rental provider understands that they must understand they must not relet this premises to any other person other than the person they have named in that stat dec.
So what happens, Lyndall, if you find another rental property to move into? Can you move out early?
Yeah, that's a good question, Kirsty. Well, the renter can give a 14-day notice to vacate in some circumstances, because the rental provider or their family is going to live in the property, or the property is going to be sold. There are some circumstances where they can move within the 60-day time frame, but the renter still needs to seek legal advice.
Yeah.
So Dear Landlord by Justice Connect, Tenants Victoria, Consumer Affairs are really good online resources, and offer renters guidance with their tenancy issues.
Awesome. Thank you, Lyndall.
Right.
Now we're chugging along really quickly here, so I apologise. And so I think if you have any questions that are popping up while we're talking, please pop them in the chat box, and we'd love to have a chat with you. Even if we just have a general chat, that's fine too. So the reasonable proportionate test. Now this is a new addition that we are so happy to have, because even though there's been a lot of doom and gloom around all the changes and what that means, it's before this came in, before the reasonable proportionate test came in, vacate, they just didn't have the power to consider certain impacts on an individual or family for that matter. So if they were terminating the tenancy, they were bound by what was in that act, and it certainly wasn't. You certainly weren't allowed to have the reasonable proportionate test. That's unless there was a mental health treatment order in place for that person, and then considerations would be made, but not like your magistrate's court where there's lots of factors that come into play. So we are so happy about that. So what does it mean? It's a legal test, they call it, about whether a renter should be evicted or not. And for every application to vacate for a possession order, regardless of what the reason may be, vacate must only grant the possession order if it's satisfied that is reasonable and proportionate to do so. So that's any reason. It can be even if it's for danger or damage to the property, rent arrears, of course, but yeah, across the whole board, which is fantastic to see. So things that now must be considered by VCAT when making their decision are the mental health impacts should the renter become homeless, any caring arrangements that renter has, the implications is that this will have on the family, as child protection will more than likely become involved if the family is homeless with no one to turn to and nowhere to stay. And also, does this person have any connections to established essential services? And indeed, the lack of housing options available, and we're all aware of that at the moment. So I hope that's clear enough for everyone. Look, there's much more to it than that, but we just wanted to make it simple and easy to understand. Would anyone like to ask any questions?
We've got 2 questions in the chat. One is from Peter about how can a tenant enforce a no smoking in an apartment block via real estate agent, body corporate, or both?
Can you just repeat that first part again?
Yeah, it says, how can a tenant enforce a no smoking in an apartment block via real estate agent, body corporate, or both?
How does the tenant enforce that?
Yeah.
Well, if we're talking body corp, that's a whole other different legislation. So I would rather not comment on that. And this also is, so the information we're giving today is also, it's around private rentals. So you've got a whole other things that come into play, like you've got your rooming houses and you've got caravan parks, which is, it's a total different ball game again. So I'm a bit confused by the question, but I'm a bit reluctant to provide information. So I'm just wondering why a tenant would want to enforce that when it would be the rental provider or the body corp that would be enforcing that. Can that person please clarify?
I'm thinking it may be due to the tenant being around smokers.
Oh, okay.
Yeah.
So on common ground. It's tricky, isn't it? When it comes to legal questions, there's just no one simple answer. We need more information to answer that.
We would definitely need to look into it, but just off the top of my head, which isn't brilliant at the moment because there's been so many changes, but I don't think a tenant can enforce a no smoking. put it this way, the Residential Tenancy Act doesn't cover for a tenant to be able to do that at this stage. That's my understanding. But if the person who asked the question wanted to, you know, get more information about it, that we'd have to look into it.
Because I was thinking maybe around the sorry, I've gone blank. Your quiet enjoyment of your property. If you're on a high rise, for example, and people are smoking and it's encroaching on your quiet enjoyment, I don't even think that anything could happen with that. I don't know. Sorry.
No, I think you're right, Kirsty. I think that would be a legitimate quiet enjoyment issue. Yeah. Yep.
Could the tenant possibly approach the real estate agent or body corporate to enforce a rule like that? They could make a request.
They could make a request.
Yeah.
Yeah, it would be up to them what they decide to do.
We have another question from Pauline asking about the rent arrears. If they are due to COVID and no work, does the 5 strikes still apply?
Okay, so we're talking about this. That's the transition phase that we're talking about. We're going into now. So by now, actually, it's hard to say, Pauline, because there's still this. We haven't seen any matters come through to us, so I can't speak from our experience. But there is a transition stage, and I've only just become aware of that recently myself. And we've had multiple trainings from the wonderful Tenants Victoria. So it's still all sinking in. So I would suggest that you make your way over to their website and just type that into their search engine, and they'll be able to tell you.
We have another question from Jacqueline asking about her ex-tenant hasn't been taken off the rental agreement. And what if they try to come back?
Lyndall? Is this a landlord's question?
Yeah, it's a landlord's question. I would be directing the landlord to talk to Consumer Affairs.
Yeah.
You'll get the best advice from them about that.
Definitely Consumer Affairs. Yeah.
Any more questions, Alia?
Yes, we do, from Monica. If the agreement was signed in 2020, does the professional cleaning law apply? The agreement said the tenant is required to show a receipt of steam cleaning carpet and mattress clean at the end of tenancy, and the agreement was signed before the tenant moved in. After the tenant moved in, she has done a condition report, and the unit she entered is not as clean as it was described. Definitely not professionally cleaned beforehand. Does the tenant have to get someone professionally to clean the unit?
The incoming tenant?
I'm thinking when Monica moves out.
I would suggest that Monica takes lots of photos of that property that she's in, and leaves it reasonably clean when she moves out, and she'll have a very good argument if the rental provider pursues her for costs for professional cleaning.
Also, if it says on the condition report that it wasn't, I might have misunderstood that, but if it says that it's not as clean, if the tenant put it's not as clean as what the landlords say it is on the condition report, that's still evidence too.
Yeah.
Yeah, the questions around when things come into play, if things have been signed or agreements entered into prior to the, I don't know about you guys, I'm a little hazy on that stuff because of the transitional period.
So I think a lot of what we've spoken about applies to tenancies signed on like the 29th of March, I believe.
Yeah, so with each issue that's prior, we have to look at the transitional regulations case by case, I think, to give a proper answer.
Yeah.
Just to go back to Jacqueline's question about the ex-tenant hasn't been taken off the rental agreement, they've clarified that they're the first tenant and the other ex-tenant is the one who has moved out and taken their belongings, but they believe they've been kicked out. So it's two people renting the one property.
So this is a little bit tricky because it becomes, I guess, tenant to tenant in this situation. You could probably have a chat to the real estate agent about what's actually going on and why this person thinks they were evicted from the property. But I'd definitely be seeking some legal advice through Tenants Victoria.
We've got a question from George. If the landlord wishes to renovate the property and seeks to vacate the property, can the reasonable and proportionate test apply and deny the vacation of the premises?
Absolutely, yes. Yes, so it would depend on the extent of the works taking place, whether they can just work around him, if he could just possibly move out for a month, or yeah, there's lots of factors that come into play, but definitely the reasonable and proportionate test will be applied.
There's also a lot of evidence required with that notice for
Yeah.
it to be valid as well. Yeah.
Yeah, they can't just say, oh, we're ripping up the carpets and repainting. That's not a significant it's not significant works carried out to the property that you can't possibly live there while that's occurring.
Back to Monica and the cleaning professionally. She's stated that the property agent usually gets the tenant or renter to sign the agreement before they can move in.
With the old legislation, yes, they did, and they would also do that with the carpet cleaning as well. If it's not in the legislation, then it doesn't matter what they write on that lease. It can't be enforced. So there's an old saying, you can't legislate outside of the legislation. Reasonably clean is something that you need to keep in mind. If the property has been professionally cleaned prior to you moving in and there's evidence of that, and they seek for that property to be in the same state as when you moved out, and this hasn't come up in vacate yet, so it's so hard to give you a proper answer, but I'll just tell you what I'm thinking. So if you're leaving that property and it is in really good standard to a professional, I'd be surprised if a reasonable member would rule against you to have a professional cleaner come in when you've left it in a professional standard. Would you agree, Lyndall?
Yes, definitely agree. Yeah.
But we can't always guarantee what a member might rule, so you'd never never like to say, oh, well, this will happen. It's their interpretation of the law.
Yeah, and they'll rely on the photos taken and condition report, everything that you've mentioned.
Yeah, so that's a pretty good reminder to people. We just can't stress enough to when you move into a property to take a ridiculous amount of photos. Any little mark you see, take that photo and mark it on the condition report. And get it back to them.
Keep a copy.
Keep a copy.
Yes.
Yeah, because that's a big one that comes through.
We've got a question from Camille. If a tenant signed a 12-month fixed term agreement and has decided to provide notice 2 months before the agreement end date, however, the tenant has lived in the property for 6 years, does the tenant have to pay 2 months of rent?
Okay, can you just please, I'm sorry, can you please say that again?
Okay, so if the tenant has signed a 12-month fixed term agreement
Yep.
and has decided to provide notice of 2 months,
Mhm.
for 60 days before the agreement end date, and the tenant has lived in the property for 6 years, does the tenant have to pay the 2 months of rent? So the last 2 months of tenancy.
No, well, it's gone from a fixed term over to a periodical. Then, if he or she's been there for 6 years, and they've originally signed,
they might have signed a new lease. They could have signed a new lease and be on a new 12-month lease.
If that's the case, then yes, they are responsible for that tenancy until the end. Now, there's a whole other narrative that goes with that, which I won't go into today, but basically, yes, you are responsible for that tenancy. If you don't find someone else that's appropriate, or they don't find someone else appropriate in that time. If it's just ticked over to what people refer to as month-to-month periodic lease, then that tenant can give 28 days notice. Is that, 28 days notice, and just leave. But not if you're on a fixed term. So you need to make sure you clarify what you're on before you make any decisions, and ring us or ring Tenants Victoria, and we'll guide you through all that.
There's another addition for Monica. It's an additional terms in the agreement signed in 2020, and wondering if the new legislation applies to that back then. So I think that might be, it might be needed to have a further discussion if they give us a call.
Yeah.
Like what Kirsty said before, you can put all sorts of additional things into the lease, but if they're not covered by the legislation, they're not enforceable. So we would need to see what those additional things were, and to be able to make it, to give correct advice.
So you'd be referring to the Residential Tenancy Act and the regulations.
Thanks, Monica. Sorry if we're not that clear, but yeah, we'd love to answer your question. If you want to contact us, please do, and we'll go through it in much further detail. How are we going, Alia? We've got.
Jacqueline has asked a really good question. How many people rent in Victoria?
Wow, millions.
A lot.
Millions. Yes, but I couldn't give you the exact data on that. I apologise. I'm not ready for that question. There's a lot of us, put it that way.
So according to this, the entire tenant population in Victoria is approximately 1.26 million people.
Ooh, in Victoria.
Yeah, that's just Victoria. Questions come through from Jasmine. Hi, is it better to enter into a sublease agreement or a normal lease if you are moving in with 3 other people, so 2 couples?
Yeah, that's it always ends in tears. That's a decision that you should make for yourself, an informed decision. And again, sorry to sound like a repetitive response, but I'd prefer to go into questions like that with the individual, because it just all depends on, income and relationships and options. I wouldn't want to advise anyone really how they should make their decision, but I'd like to get the opportunity to give them all the information, and then they can make that decision themselves.
If you're subleasing, then you still have a rental provider and renter agreement similar to if you were leasing the property directly, but it's between you and the person you're subleasing. So you can still make applications to vacate and have the same laws apply, but it does sometimes just get a bit tricky.
Yeah, I think Consumer Affairs outlines what each tenancy is and what you can and can't do in those situations. So you can check out their website and they'll give you a bit more information, detailed information.
And Jacqueline has asked, where is the list of the 137 laws for a renter to read? I wasn't sure where to look or print off.
Consumer Affairs has quite significant information around the changes on their website, so yeah, check them out online.
And Lynn has asked, I have the rental from hell, and last July 2020 I lodged a compensation claim with VCAT for over $10,000, but to date VCAT has not heard my claim, and now the rental provider has given me a 60-day notice to vacate. Can you comment on how I can get my claim heard?
Compensation claims are not being heard at the moment because of COVID last year. There's a bit of a backlog at VCAT, and they're hearing some matters, but not compensation claims. They might have started hearing them, but it's going to take months and months and months for them to catch up.
And also the claims over 10,000. Did she say?
It does say for over 10,000.
Yeah. So then anything above 10,000, then there's another act that comes into that, and it's the Australian Consumer Law, but there's a little bit more into it. I can't remember what it is. It's out of our jurisdiction, but that's also got to be included in that claim as well. So you might want to go back and have another look at your application and seek legal advice.
And that's all we have for questions.
Right.
Jacqueline has said thank you for answering the questions.
Thank you, everyone. We appreciate it. I've really enjoyed doing this. We're pretty new at it, so apologies if there's been some little hiccups along the way by me. Thank you so much for Alia moderating this, and for putting the slides together, and for Leah and Lyndall for presenting with me today. I've really enjoyed it. And please, as we've been saying, going on about it all throughout the presentation, contact us. Yeah, thanks, Alia.
Yeah.
Tenants Victoria, wonderful organisation. Justice Connect, fantastic. Consumer Affairs, amazing. And Consumer Affairs is great because they are impartial. So we're funded to support tenants and not landlords, as are Tenants Victoria, Justice Connect. But Consumer Affairs provides information to all parties. So that's also good to note. And then we've got, I can't see that one now, I've clicked on something. Then what's the last one there?
VCAT.
Good old VCAT. They'll have all your application forms and your notices to landlord and things like that in there. Everyone's recently updated their website, so it's very clear. And we have also updated our website, and there's plenty of opportunity there to self-refer if you want. You need information and support around your tenancies. Thank you again. I really appreciate that you taking your time out today and to spend with us, and we hope that you've got some benefit out of this presentation today. Thank you all. Thanks.
Thanks, everyone.